The real sting for employers in this jurisdiction, in the general protections jurisdiction, is there is what we call the reverse onus.
Let's start with getting a bit of a clear understanding on the unfair dismissal claim. What is an unfair dismissal claim and what is a general protections claim? So I think this is a really, really important one to start off with. Jenna, I think I'll kick off with you, and then Daniela, if you've got anything you'd like to add, please jump in there.
Yeah, perfect, Paul. And I think it's a good starting point because these two are the main types of claims that come from an employee's perspective that land on our desk as employers. There's a multitude of other different claims, but today we want to talk about these two because that's where we're seeing such an increase, or the Commission's seen such an increase of claims, which has resulted in a bit of a change in process, and we're going to get to that. But as a starting point, and once I've yabbled on a bit, hand it to Daniela from more that technical legal if I've missed anything. But unfair dismissal is one type, and that claim is judged on whether the termination was harsh, unjust, or unreasonable. So when you lodge a claim, that is what you need to be able to prove to be successful. It focuses on, was a fair process followed that led up to the termination? So unfair dismissal, there must be a termination involved. It focuses on the reason of why the employer made the decision to terminate your employment from an employee's perspective. Questions that will be asked is, was there a valid reason? Was the employee given an opportunity to respond? Was procedural fairness followed? And what do some of those terminologies mean? We'll get into later. But that is the main aspects. To be able to lodge an unfair dismissal claim, you must be employed with your employer for at least 6 months, unless you're a small business, which is 14 heads and under, and there's 12 months qualifying. So you can't work for someone for 2 months, be terminated, say, for example, under probation, and then lodge an unfair dismissal claim, because that is not criteria. So that's very high level. It costs $80 odd, closer to 90 now, to lodge a claim. If the employee is successful and a negotiation is made, they get that $90 odd back. So they can represent themselves. It's encouraged. So it's very easy for an individual to lodge a claim. You don't need a lawyer, so to speak. General protections is much more broader. Back when I started in my HR career, we didn't see these claims as much. Now they're just as popular and common as unfair dismissal claims. And some of the reasons why we'll get into later, but it relates, and to lodge a general protections claim, it relates because there must be adverse action being taken because someone exercised their workplace rights due to a protected reason. And I'll let Daniela give us an overview of what those workplace rights and protected reasons are. The difference here is it doesn't always involve termination. So I could still be employed and lodge a general protections claim to my employer. Okay? And sometimes there could be one issue and the person could lodge multiple different claims. As employers, we would want to focus on, don't try and predict what might happen. Come back, make sure that you're doing everything right from the get-go, following the process, getting experts in when you need, if you're going to lead to a termination, for example. And the difference with general protections is there is no minimum employment term. So I could be employed by my employer for 3 days or 3 hours and lodge a claim. And there's also no cap on compensation, whereas if you're doing an unfair dismissal, it's a 6-month, 26-week cap that could be awarded. Now, we don't see that awarded much. It's generally between 4 and 8 weeks type of thing, but that's, you know, worst case. So that's my high-level, simple overview for our audience to be able to understand the difference. And if you're an employer, if you are going to receive a claim, most of the time it will be an unfair dismissal or general protections claim. I'll hand over to Daniela to give her legal spiel on it.
Certainly. Look, you hit the nail on the head, Jenna. That's probably the cleanest distinction between what we see in unfair dismissal and general protections. I like to see it as unfair dismissal was there a valid reason? Was it fair? How was the process undertaken? General protections is, why did you do it? Why did the employer do it? And did you do it for the wrong reasons, the protected reasons under the Fair Work Act? It's a much more technically complex claim. It's much more forensic than an unfair dismissal claim. And Jenna mentioned before adverse action being taken for protected reasons for exercising a workplace right. So the Fair Work Act sets out all of these reasons why an employer can't take adverse action against their employee. And they might be things like making what we refer to as a complaint or inquiry in relation to somebody's employment. It might be because they exercised a workplace right to take protected leave, so annual leave, personal leave, long service leave, because they have things like family and carers responsibilities. Maybe they were discriminated against because of, you know, for various reasons under your state and territory discrimination legislation, because they were entitled to some sort of right or benefit under an industrial instrument, whether that's your Fair Work Act, a modern award, an enterprise agreement, all of these instruments that, you know, govern and regulate employment relationships. So, like I said, it's a much more forensic and complicated claim, and it's you often see a lot of, or we see a lot of, you know, unmeritorious claims. You know, people think that raising something like a simple grievance in the workplace is a complaint, but it's actually not. It has to be a specific complaint in relation to your employment. So it might be raising a complaint into your wages. You know, you have an entitlement to a specific amount of wages. You make a complaint in relation to that. So it's quite complex. The real sting for employers in this jurisdiction, in the general protections jurisdiction, is there is what we call the reverse onus. So once an employee raises an allegation, it is up to the employer to disprove it. So it can become quite complicated, and it's where your documents and the process that you undertook beforehand is really important, because the last thing you want is to, you know, dismiss somebody because you say there was misconduct or underperformance, and then you go back in your string of emails and, you know, you've got managers complaining about the fact that this person took sick leave or raised a complaint or something, and all of a sudden the true question about why you took that adverse action is important. And then the last thing that Jenna mentioned is correct, that it doesn't just have to be dismissal. So there's two general protections claims that we can make in the Fair Work Commission. It's a non-dismissal and a dismissal. Non-dismissal claim can be made during the employment. So it might be that you got demoted, or that you were treated unfairly at work, you were injured in the course of your employment. So, yeah, there's a variety of claims, a variety of, I guess, of different general protections arguments that can be made, and they're pretty complex. And the biggest thing, if they don't settle in the commission, it's off to court. So if we don't resolve at a conference, we're off to the Federal Circuit Court and Family Court, or the Federal Court, whatever the appropriate jurisdiction is, and they rarely stay neatly confined to one issue. It often becomes a much broader dispute where we see things like breach of contract being brought in, whistleblower. So it's very, very, very quickly, what was a relatively contained workplace issue can become a much, much broader piece of litigation on your desk.
And would that, does that cover, I suppose there's all sorts of different types of employment, so casual, part-time, full-time. Does it cover all?
Or a general protections claim, yeah.
Okay. And what about unfair?
Yes. Well, unfair dismissal is generally for permanent employment, but there are circumstances where a casual employee might bring an unfair dismissal claim. So if they, because casual employment technically is your engagement ends after each period of employment, whether that's each shift, each day, whatever it is, you technically, it's harder to, you generally can't make an unfair dismissal claim. But if you can prove that you're regular and systemic, employee, and you were more properly characterised as a permanent employee, then you might be able to bring an unfair dismissal claim. We would generally
I definitely wasn't aware of that. So in a casual situation, at the end of that shift, technically that ends, and then their next shift restarts.
Technically, it's a little more complex than that when push comes to shove, and we're talking, we're dealing with a practical situation. But yeah, at common law, it's the end of an engagement is the end of the employment, and it starts again.
Interesting.
The next time you work.
And that's where we see a lot with our clients. They engage individuals on casuals that should technically be potentially permanent part-time, because there is a pattern of hours and days of work week in, week out. It's predictable, and it's those people, if they want to lodge an unfair dismissal claim, if they can prove that the relationship is actually more of a permanent than a casual, they've got more of a chance of it holding. So that's why it's really important that people engage individuals on the right nature of employment.
Absolutely. And it can get even broader than that as well. As Jenna would see, you've engaged a casual, and obviously casuals have very different entitlements to a permanent employee. And suddenly it's not just, actually, I was properly characterised as a permanent employee, so I have an unfair dismissal claim, but there's an underpayment of wage claim. They didn't receive the correct entitlements. There's penalties involved. So getting the regulation of the employment relationship right at the get-go is one of the best things that you can do.